It's day 4, my UPSC warriors, and it's time to dive into the heart of the Constitution. Today's target prelim session is all about your fundamental rights, the DPSPs, yes, those guiding principles, and of course your fundamental duties. Basically, the who, what, why, and how of being a responsible Indian citizen. Think of today's session as unlocking the secret superpowers hidden within the Constitution. So grab your cup of favorite brain fuel, put on your thinking caps, and get ready to conquer those prelims questions. Today we'll not just learn about these rights, but also how to uphold them and become the best citizens we can be. Remember, knowing your rights and duties is not just for the exams, it's for life. So let's get constitutional. We have the schedule here for you. You can follow this schedule and plan your revision accordingly. Today is day 4. We have one more polity session tomorrow, and then we'll have geography, ancient history, economy, etc. So let's begin with the very first question. How many of the following are a part of state as per Article 12 of the Indian Constitution? Reserve Bank of India, Zilla Parishad, High Courts, Central Vigilance Commission. So Article 12 Part 3, it defines what's a state or what constitutes a state, but only for Part 3 of the Constitution. This definition should not be used for all other places. Anyway, Reserve Bank of India, of course, yes, established 1934, the Act of 1934. So as per the Ajay Hasia case, it's a very important, very famous case. The Ajay Hasia case was one where Supreme Court said that any body which has been created by a law or by an executive order will be considered to be a part of state under Article 12. Yes, of course. Zilla Parishads, yes, in fact, there have been multiple judgments of Supreme Court which have clearly stated that Zilla Parishads, the local bodies, are a part of state. Madras Pinjra Pole case 1961, Dr. Dinesh Kumar case of 1986, a very popular case. So all these cases are ones where Supreme Court has said that the local bodies are also a part of state. Then the high courts, interestingly, superior courts like the high courts or the Supreme Court, they are not a part of state under Article 12's definition. Supreme Court has said in the Rupa versus Ashok Hurra case 2002. I hope you remember this case because this was a case which gave to us a very unique concept. What concept? The concept of, whenever you challenge a Supreme Court judgment, you request the court that, my lords, please review your judgment. And if it fails, you can again file a petition. That's the concept. What's that concept? The concept of curative petition. This concept is a judicial innovation. You won't find this in the Constitution because it has come from the Rupa Hurra case. And it was in this case that the Supreme Court said that the superior courts are not covered under the definition of state under Article 12. So 3 is out. CVC, yes, of course. CVC, a statutory body, initially an executive body, later on a statutory body, hence covered under the definition of state. So 1, 2, and 4. How many? 3 only. Okay, that's there. Second question. Consider the following statements about Article 14 of the Indian Constitution, which embodies the right to equality before the law and equal protection of laws. So Article 14 applies equally to citizens and foreigners residing within the territory of India. Okay, that is correct, of course. There are only few rights which are available only for citizens. What are they? Please remember 15, 16, 19, 29 and 30. These 5 fundamental rights are meant only for Indian citizens. All other rights are meant both for citizens as well as aliens, that is, foreigners. Number 2, it guarantees absolute equality and prohibits any discrimination by the state against any individual. In our country, rights are not absolute. We'll always have exceptions. So, absolute equality does not exist, right? Rights in our country are qualified in nature, meaning reasonable restrictions can be imposed on these rights. Something as simple as the fact that if you commit a murder, a case registered against you, but if the president or the governor commits a murder, no case. Why? Because there is something called immunity given to the president and the governors, right? Then we have concepts like parliamentary privileges to our MPs, to our MLAs, MLCs, etc. So 2 is wrong. Number 3, Article 14 permits the state to make special provisions for the advancement of any socially and educationally backward classes of citizens. Yes, Article 14 does allow for what? Allow for something called positive discrimination, the result of which has been various provisions made in our country with respect to, say, reservation or progressive taxation. So these are all examples of special provisions being made for certain categories of people. Number 4, it ensures that laws are applied equally and uniformly to all individuals in similar circumstances. Yes, equal protection of laws, meaning people placed under similar circumstances must be treated in the same fashion without any favoritism or bias. 4 is also correct. What's the right answer? 1, 3 and 4. C is the right answer. Next question. Consider the following statements regarding the basic structure doctrine of the Indian Constitution. Basic structure doctrine. The basic structure doctrine was established by the Supreme Court in the Keshwanand Bharati case in 1973. Yes or no? Of course, yes. It's a judicial innovation which came from the Keshwanand Bharati judgment of 1973, 24th of April. Number 2, the doctrine specifies certain features such as rule of law, separation of powers, and judicial review that cannot be altered or abrogated, taken away, removed by a constitutional amendment. Yes, of course, it places limitations on the power of Parliament to amend the Constitution. And under this doctrine, no amendments are allowed if they seek to remove the fundamental rights. The big question, are fundamental rights amendable? Yes, they are. In fact, if you remember, the 44th Amendment Act of 1978 also did away the right to property. Article 19, Clause 1, Subclause F. Every citizen had a right to acquire, to hold and dispose of property. The right was done away with, and it was through an amendment after Keshwanand Bharati. Anyway, the Supreme Court also said in the same judgment, the Keshwanand Bharati case, that fundamental rights are amendable. The underlying essence of it is not, but right per se, right in itself is amendable. So 3 is wrong. How many statements are correct? B, 2 only. Next question. Consider the following statements regarding Article 15 at the commencement of the Constitution. Commencement of the Constitution, Article 15. It permitted the state to make special provisions for women and children. Yes, of course. Article 15 has a clause 3 which allows for this. Number 2, it allowed the state to make special provision for the advancement of any socially and educationally backward classes of citizens or for SCs and STs in educational institutions. In short, reservation in schools and colleges. Now please tell me, reservation in schools and colleges, was it a provision which was mentioned in the original constitution? No, it was not. It was added through modifications. So we can attribute the First Amendment Act of 1951 and also 93rd Amendment Act of 2005 to provide for reservation in schools and colleges by adding Article 15, Clause 4, Clause 5. Later on, the 103rd Amendment Act for EWS in 2019 added one more clause, 6. So 2 is wrong because the question said at the commencement, beginning of the Constitution. This date, 26th January 1950. And number 3, it allowed discrimination on the ground of residence. Article 15, does it allow discrimination on the grounds of residence? Yes, of course it does. Discrimination on the grounds of residence is not allowed under Article 16. Under Article 15, you cannot discriminate on 5 grounds. R, C, S, P. Religion, race, caste, sex, place of birth. That's it. So 1 and 3 are right. How many statements are correct? B, 2 only are correct. Next question. Consider the following statements. Article 16 guarantees equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 16, yes, guarantees equality of opportunity. Absolutely correct. Number 2, it allows the state to reserve vacancies in government jobs and posts for members of backward classes that are not adequately represented in the government jobs in services under the state. This is nothing but Article 16 Clause 4. This is the original policy of reservation in government jobs in our country. So yes, it's correct. Number 3, Article 16 applies exclusively to Indian citizens and does not extend to overseas citizens of India or non-citizens. Yes, there are certain provisions which are meant only for Indian citizens. I'll repeat once again: 15, 16, 19, 29, 30. Okay. Number 4, both center and states can make laws to provide for residence as a criterion for reservation. See, residence as a criteria for reservation can be created or can be provided, not by the state. Article 16 Clause 3 says Parliament can provide for residence as a criteria for reservation. Also, Article 35 states the same thing, that laws on this can be made only by the center, not the state. 4 is wrong. How many statements are correct? C, only 3. Next question. Consider the following statements about Article 17 of the Indian Constitution. Article 17, untouchability. Article 17 allows the practice of untouchability for only essential religious practices. Is it true? Of course not. In fact, there's a misconception. Article 17 is an absolute fundamental right. No, Article 17 is absolute, but not a right per se. Article 17 is basically a restriction that nobody will practice untouchability. So this is an absolute restriction. Under no circumstance can you practice untouchability on any ground. It is not justified. An absolute limitation. No exceptions at all whatsoever. So 1 is wrong. Untouchability is not allowed on any ground. Number 2, the Constitution explicitly clearly provides a definition of untouchability within Article 17. That has not been the case. There is no definition of Article 17, though while the discussions were going on, it referred to the idea of the scheduled caste communities facing discrimination for thousands of years, right? But there is no explicit definition of the same. Number 3, the state legislatures can make laws providing for the punishment for enforcing untouchability. No, again, not correct. Article 35 says that laws to provide for punishment for the offense of untouchability can be made only by the Parliament. Is there any law to punish for untouchability? Please write in the comment section what is a law which has been made by the Parliament to punish for untouchability. Right, yesterday I had asked you guys to write. Some of you wrote, most of them were correct. One such question I felt some of you marked or rather mentioned wrong was the original jurisdiction of Supreme Court. So some of you wrote the interstate river water disputes, etc. That's not correct. It's Article 71. So Article 71 refers to what? Article 71 refers to the fact that every election dispute involving the election of the president and the vice president will be taken to Supreme Court only. This is an example of original jurisdiction apart from federal disputes. Anyway, so today please write in the comment section what is the law made by the parliament to punish for untouchability, along with the year as well. Okay, so 1 is wrong, 2 is wrong, 3 is wrong. Everything is wrong here. How many statements are correct? So, right answer is A, none. Don't mark D in a hurry. A is none. So, always read the instruction and the options very carefully. The worst thing that will happen is you knowing the right answer, marking the right answer in your notebook, but not in the answer key, the OMR sheet. Okay. Consider the following statements about the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989, also called the SCST POA Act of 1989. The Act aims to prevent the commission of offences of untouchability against the members of Scheduled Castes and Scheduled Tribes. So please understand, to punish for untouchability, we have a separate law, okay? And to punish for atrocities against SCs and STs, see, untouchability, the law for that, which you have to write in the comment section, is only meant for scheduled caste people, okay? Scheduled caste people. But this law prevents atrocities against both SCs and STs. So it is not meant to punish for untouchability, but for atrocities. And in fact, this particular law defines atrocities. There is one section 3 of this law which defines 30 different types of atrocities. You know, assaulting a scheduled caste, a scheduled tribe person, occupying their land illegally, dumping something obnoxious in their house, or forcing an SC/ST person to eat something obnoxious, etc., or maybe disfiguring Dalit icons. It's all a part of atrocity. Okay. Anyway, number 2, the Act specifically defines what constitutes atrocities. Yes, I just said so. It clearly defines what is an atrocity. 30 different types of atrocities have been covered here. And number 3, the Act prescribes punishments only for non-SC/ST officers who willfully neglect their duties towards SC/ST individual. So let's say some of you who are non-SC/ST people become officers, and a scheduled caste person approaches you with some concern that he or she is facing because of his caste. If you willfully, deliberately neglect your duties towards that person, you will be punished under this law. The question is, will only non-SC/ST officers be punished? Yes. The law clearly says that if you are a non-SC/ST officer and you willfully neglect your duties towards an SC/ST person, you can be jailed from 6 months to 1 year. Okay, that's the amount of jail term that can be given to such an officer. So 3 is actually correct. Interesting. You know, under the untouchability laws that we have, if anybody is found guilty of untouchability, they will also be disqualified from contesting elections for how many years? 6 years plus any jail term. Please write in the comment section what section of RPA is that. Tomorrow we'll be discussing some questions on RPA. Let's see how many of you have practiced and mugged up the RPA sections. What section of RPA provides for disqualification of our members, of our MPs, from contesting elections for 6 years if they are held guilty of the offense of untouchability? Anyway, so question says how many statements are incorrect? Incorrect. How many are incorrect? Please tell me. So 2 is correct, 3 is correct. Right answer is A, 1 only. Moving on to the next question. Consider the following restrictions: sedition, friendly relation with foreign states, decency, morality, protection of interest of any scheduled tribe, and health. How many of the above are limitations on the freedom of speech and expression as enshrined in Article 19? So Article 19 is very beautifully framed. If you look at Article 19, Clause 1 has all the rights that you are enjoying. It has 6 sub-clauses. A, B, C, D, E, F has been repealed, and G, A to G. And clause 2 onwards till clause 6, we have the restrictions. So clause 2 contains restrictions on your subclause A, that is the freedom of speech and expression. And you'll be surprised that there are 8 different types of restrictions on the enjoyment of your speech and expression. Sedition is not mentioned there. Thankfully, it was not mentioned there, though we have seen that sedition as a law has been misused, drastically in our country. We should thank the Supreme Court that in the SG Wombat Kere case, couple of years back, Supreme Court instructed that no case to be filed under sedition till the government tells us what is their stand on sedition. But anyway, in the new BNS, they have not mentioned any such provision for sedition, thankfully. So this law is gone for good, but it is not there as a restriction. Friendly relation with foreign states, yes, it's a restriction. Decency, morality, yes, it's a restriction. Protection of interest of scheduled tribes. Now, this is not a restriction here, but in some other fundamental right, that is right to move freely and reside freely, right? That is Article 19, Clause 1, Subclause D and E. Okay, so this is a restriction under Clause 5 and a restriction for 19(1)D and E. It might seem technical. I would request you to go and read the entire Article 19 on your own. It's very easy to understand. Health. Health is a restriction under Article 25 and 26, not here. So this is also not covered. So this is not there, this is not there, this is not there. 2 and 3, only 2. What are some other restrictions? Other restrictions include sovereignty and integrity of India, security of the state, contempt of court, defamation, public order. These are some of the other restrictions, and of course incitement to an offense. Okay, that's it. Next question. Consider the following statements about Article 19 of the Indian Constitution. The freedoms guaranteed under Article 19 are absolute and can be restricted by the state only during a national emergency. Can Article 19 be suspended during national emergency? Yes, it can. Article 358 says the same thing, that the moment national emergency is proclaimed on the ground of war or external aggression, that is external reasons, what happens? Article 19 gets suspended automatically. That's fair, that's fair. My point is, can we otherwise place restrictions on Article 19? Yes, of course. Clause 2, Clause 3, Clause 4, Clause 5, Clause 6, these are what? Restrictions. Various restrictions are there on Article 19. So as we said, rights are never absolute. Wrong. Number 2, the right to strike is explicitly protected under Article 19. Sadly, right to protest is possible, though right to protest and right to occupy public space indefinitely, that is not there. Right to protest anywhere is also not a part of your Article 19. And right to strike is a statutory right. Just to clarify for all those people, right to strike is statutory. Why? Because the provisions for strike are mentioned in a separate law. That law is called the Industrial Disputes Act of the year 1947, where they have defined what is meant by strike. So we feel that the source of this right to strike can be traced to a law at best. At best. So if you go to this law, Section 2 subsection Q defines what is meant by a strike. That's it. So right to strike is a statutory right, not a fundamental right. So 1 is wrong, 2 is wrong, both are wrong. What's the right answer? Which statement is correct? Neither 1 nor 2. Next question. Which of the following are sources for the right to be free from adverse effects of climate change? Recently, there was a very interesting judgment. Just this, I think, last month, 8th of April 2024. So, recent judgments become important because UPSC has asked such questions in the past on privacy or right to marry, etc. So, what had happened? This case was the M.K. Ranjit Singh case of 2024. Okay. So, in this case, what was the point? See, the understanding of right to equality as per Article 14 and also right to life according to Article 21 should be considered in the light of this court's ruling. Very important. And also the states, the countries, national and international commitments and the scientific agreements on climate change and its possible negative impacts. And this consideration also reveals a right to protect or the right on the protection of our climate from harmful effects of the climate change. This consideration is very, very important because it's crucial to recognize that enforcing this right, courts also need to be mindful of one more thing. The other rights, what rights belonging to the communities impacted, the right to avoid displacement, and other issues as well. See, what's the underlying idea? If climate change and environmental degradation lead to acute food and water shortages in a particular area, poorer communities will suffer more than the richer ones. So, what happens? The moment your climate is affected, your environment is affected, the poorer suffer more. Right to equality gets impacted. The right to live with dignity, right to life gets impacted. Right to equality gets impacted and right to life gets impacted. 1 and 3. A is the right answer. See, this judgment primarily was a part of this entire issue that had happened. So these observations Supreme Court made are a part of the decision where a 3-judge bench had constituted an expert committee to examine the scope, the feasibility and the extent of installing overhead and underground power lines in areas considered priority for the conservation of the Great Indian Bustard. So in the western part of our country, the Great Indian Bustard, the birds, these birds fly, and because these transmission lines installed there through the generation of solar energy are not being sighted properly by the birds tend to collide with these transmission power lines and lose life. So the Supreme Court had already instructed the Rajasthan government, the Gujarat government to install bird diverters, and had said that we need to look into whether we have to be so obsessed with solar energy in these areas or not. But also you have to have a balance because India is also party to various agreements where we have to bring down what? Bring down the reliance on the non-renewable sources of energy, right? So that's also there. So a fine line has been traversed by the Supreme Court, and Supreme Court said that yes, everyone has a right to be free from the negative effects of climate change. If it does not happen, it impacts equality, it impacts right to live with dignity, Article 21. So 1 and 3 being the right answer. Next question. Consider the following statements regarding Article 20 of the Indian Constitution. Article 20, 3 aspects to it. Number 1, it guarantees that no person shall be subjected to a penalty greater than what could have been inflicted under the law in force at the time of the commission of the offence. Yes or no? Of course, yes. No ex post facto law. No ex post facto law. 1 is correct. Second one, it however allows A retrospective application of civil laws to enhance penalties for offences already committed. Retrospective application of civil laws to enhance penalties for offences. No, no, no. Civil offences, civil laws can have a retrospective effect, of course, but if it seeks to enhance a penalty, sorry, that's not possible. So 2 is wrong. Which statement is correct? A, only 1. Next question. Consider the following provisions: free and compulsory education to all children of the age 6 to 14 years. Okay. Provision for early childhood care and education to children below the age of 6 years. Okay. And duty of every citizen to provide education to his or her child. Which of the provisions mentioned above were added through the 86th Amendment to the Constitution? Free and compulsory education to all children between age 6 to 14. Which article? 21 capital A. ECCE, early childhood care and education below the age of 6. Which article? This is article 45. Okay. To DPSP, modifications done. And duty, article 51 capital A, clause K, duty of every citizen. Yes, all these 3 were added through the 86th Amendment of the year 2002. So right answer D, all. Next question. In a recent Supreme Court verdict limiting the provision of coverage of MTP, medical termination of pregnancy, to only married women is a violation of which among the following? So this was a case, Principal Secretary, judgment of 2022, X versus Principal Secretary. So a 3-judge bench said that unmarried women are entitled to seek abortions for pregnancies up to 20 to 24 weeks from consensual relations, declaring it unconstitutional to exclude them from the MTP Act, the Medical Termination of Pregnancy rules as well. See, the court emphasized that all women, irrespective of the marital status, have the right to safe and legal abortions, aligning with the principles of equality and non-discrimination. Principle of equality, because earlier the law said that only married women were allowed to get the help of a medical practitioner, a registered medical practitioner, doctor, with respect to their termination of pregnancy. But Supreme Court said no. Why only married women? Every woman, irrespective of her marital status, has a right to get a medical termination of pregnancy under the Act and the said rules. Okay, a judgment of Supreme Court in the year 2022, X versus Principal Secretary case, 2022, Article 14 gets violated otherwise. Next question. Consider the following statements regarding the doctrine of basic structure. The term basic structure was added to the Constitution of India through the 44th Amendment. Nonsense. This is a judicial innovation. This term is not there in the Constitution. It has not been added. It is just a Supreme Court innovation. It is the interpretation of the Supreme Court. So 1 is wrong. Number 2, it does not apply to laws which are placed under the 9th schedule. It does not apply to laws placed under 9th schedule. So through the First Amendment Act, we had established for ourselves one 9th schedule, a safety box, where any law you make, and if you place that law in this safety box of 9th schedule, that law would be immune from judicial review. But Supreme Court said that, sorry, we'll take it, but if you make a law and place it in the 9th schedule and the law violates basic structure, then that law can be judicially reviewed. So basic structure is applicable even on Schedule 9. Nothing can be done to violate the basic structure. So please understand, right? That's it. 2 is wrong, because it does apply to basic structure, does apply to 9th schedule as well. And number 3, Bangladesh is the only country apart from India that has recognized the principle of basic structure. No, a very good example is Uganda as well. Uganda in 2017-18, one court had also not only recognized, also gave due credit to the Keshwan Bharti judgment, like Bangladesh in the Anwar Hussain Chaudhary case of 1989. They also quoted Supreme Court's basic structure doctrine as a concept. So this is wrong. How many statements are not correct? Not correct. All 3. C is the right answer. Next question. Consider the following statements regarding Article 22 of the Indian Constitution. Under Article 22, an individual detained under preventive detention has a right to be produced before a magistrate within 24 hours of detention. Yes or no? Under Article 22, an individual detained under preventive detention. Sadly, no. Article 22, yes, gives us the right, 3 rights. 1, within 24 hours to be taken to a magistrate. Number 2, we will be given what? Legal help, meaning we have a right to some kind of legal practitioner or lawyer. And number 3, we have a right to be informed of the reasons, the ground for arrest. But these 3 rights are not given to those people who are enemy aliens and those who are arrested under any preventive detention laws. Sorry, no right for you. And the provision of Article 22 applies uniformly to both Indian citizens and foreigners. No, it does not. For enemy aliens, there is no such right of being informed, etc. So this is wrong. Number 3, laws on preventive detention can be made only by the Parliament. This is also wrong. Why? Because preventive detention as a topic is a part of Union List, of course, entry number 9. It is also a part of concurrent list, entry number 3. And if it is a part of concurrent list, then both the center and the states can make laws. So not just the Parliament plus state legislature can also make laws. So 3 is wrong. How many statements are not correct? Again, how many are not correct? All 3 are not correct. C is the right answer. Next question. Consider the following statements regarding the contempt of court in India. Willfully disobeying a court's order could amount to civil contempt of court. Okay. And the criticism of judicial decisions, regardless of fairness, amounts to criminal contempt. See, what is civil contempt? Civil contempt means you deliberately, willfully, knowingly disobey a court's order. Correct. No problem. 1 is right. Agreed. What is criminal contempt? Criminal contempt means what? If you scandalize the court, horrify the court, or if you attack the dignity of the court, lower the authority of the court, obstruct the course of justice, that's called criminal contempt. Making unnecessary, baseless allegations against our court. That is called criminal contempt. But sadly, fair criticism of judicial actions is not contempt. There is a law called Contempt of Courts Act of 1971. That law has a section 5 which clearly says that any fair criticism of judicial actions will not be deemed to be contempt. It is allowed. So regardless of fairness is wrong. It will not be called contempt, right? So 2 is wrong. Which of the statements is or are correct? A, 1 only. Contempt of court, extremely important. Next, consider the following statements regarding Article 24 of the Indian Constitution and child labor laws in India. Employment of children under 14 years is permitted only in non-hazardous roles such as domestic help, hotels and restaurants. Yes or no? One simple question to all of you. Can you employ kids under 14 as domestic servants? Yes or no? The answer is no. And for those who are saying yes, I mean, this has been the law since 2006 only. So we have a law in our country called Child Labor Prohibition and Regulation Act of 1986. And as per this law, originally kids under 14 were not to be employed in certain industries and certain industrial processes. Almost 65 such processes were mentioned. In 2006, the law was modified and kids under 14 were not to be employed as domestic servants in hotels, dhabas, restaurants, etc. Right? And later on in 2017, the law was again modified. And now kids under 14 are not to be employed anywhere. There is a blanket ban. Only two exceptions. What are the two exceptions? Exception number one is a family-run enterprise. If the family runs an enterprise, then the kid can help the family after school hours. So if let's say somebody's father, a kid's father, somebody is running a vegetable shop, the kid after his or her school hours can give a helping hand to the father. That's it. Family run enterprise. There is one more exception where kids under 14 are allowed to be employed. What is that exception? Please write in the comment section. Let's see whether you know that exception or not. Otherwise, blanket ban completely on the employment of kids under 14 anywhere. So one is wrong. Number two, adolescents cannot be employed in non-hazardous industries. Firstly, who is an adolescent? So in 2017, this law was modified. Okay, amendment was made, and a new category was created. Under 14 child, 14 to 18 is called an adolescent. Now these kids were not to be employed in hazardous occupations. Otherwise, they can be employed. What is hazardous? Things like mines, explosives, and inflammables. These three industries are said to be hazardous industries. Coke industry, right? Iron ore, bangle making, etc. I mean, if you look at the Factories Act 1948, the Schedule 1 of that law comprises list of all those industries which are called hazardous in nature. Anyway, so yes, adolescents cannot be employed in hazardous ones. In non-hazardous ones, they can be employed. 2 is also wrong. Number 3, violating child labor laws in India can result in a monetary fine but not a prison sentence. Sadly, that's not correct. You have the provision for fine, I agree. Fine is from 20 to 50,000 per kid employed, okay? And there is also a jail punishment which is up to 2 years of jail. That's also there. So it's not just a monetary fine, you can also be given a prison sentence. 3 is also wrong. How many statements are correct? Right answer is D. None of the statements mentioned here are correct. Moving on to the next question. Consider the following statements regarding the features of Indian secularism. It advocates mutual exclusion of state and religion in order to protect individual freedom. Mutual exclusion. Just to clarify, Indian secularism does not believe in strict separation. We believe in principled distance or principled intervention. Okay, meaning, in fact, if you refer to our article 25 clause 2 subclause B, it clearly says that the state can provide for social welfare and reform. If in your religion there is some practice which is discriminatory, the state will interfere and remove that practice. So there is no mutual exclusion. We keep a distance, but based on principles. So it cannot be illogical. If your practice violates somebody's right to life, health, morality, public order, the state can interfere. So 1 is wrong. Number 2, it forbids state from providing any type of financial aid to any specific religious community. No, that's not true. The state can provide for financial aid, but the idea is promote all religions equally. Okay. A single standard civil law is employed. A single standard civil law. Do we have a uniform civil law, uniform civil code in the country? We have this idea that we should in future. Article 44 expects the state to have a law, but as of now, it's not there. It prevents the state from discriminating against any citizen on the grounds of religion. And that is true. This is correct. 4 is correct. How many statements given above are correct? Only one is correct. A is the right answer. Next question. Which one of the following options best reflects the chief purpose of adopting a democratic form of government? Democratic form of government, people's participation, executives accountability, etc. Okay, all political parties in the country will be represented in the parliament. There is no guarantee of that. It creates a stable government with the power to make quick decisions. In fact, democratic form means everybody's voice is being heard. More deliberations, more discussions, slight delay in the decision making, but that's okay because the idea is participation. The idea is accountability. Wrong. To protect the sovereignty and integrity of the country, it has got no relationship with this. So D has to be right. And what is that? To make the executive accountable for all its actions. Yes, of course, representative democracy. We ensure that the MPs make sure by asking questions from the government, right? Asking questions regularly, ensuring that the executive is accountable to the legislature. And what is legislature? People's representatives. We vote for them, we choose them to ultimately go and sit in the parliament and ask questions from the government. So D. The DPSPs are enshrined in Part 4 of the Indian Constitution. How many of the following statements about DPSPs is or are correct? They are fundamental in the governance of the country. See, for DPSPs, you should always remember Article 37. If not the other provisions, at least Article 37, because Article 37 provides for the essence of what exactly is DPSP, right? So yes, DPSPs are fundamental in the governance of the country, even though they are not directly enforceable by the courts. They are non-justiciable. They are directly enforceable by the courts. Of course not. This is wrong. They serve as guidelines for the state to formulate policies. Yes, it's the duty of every state and the center to make sure that they keep the DPSPs in mind while making laws in the country. So 3 is correct. And they are amendable by the parliament through a simple majority. Sadly, that's not the case. You can amend it, but it requires a special majority, the same majority required to modify or amend the constitution. 2/3 present and voting, more than 50% total strength. So 1 and 3 are correct. How many are correct? Only 2. B is the right answer. Okay. Examine the following assertions regarding the DPSPs. Let's see. Article 39 B and C of the Indian Constitution, which are a part of the DPSP, prioritize the distribution of material resources of the community to subserve the common good and prevent the concentration of wealth, and are judicially enforceable under Article 32. See, 39 B and C's definition is correct, but DPSPs are not judicially enforceable. That's a problem. So 1 is wrong. Number 2. The 42nd Amendment Act of 1976, influenced by the philosophy of socialism, added several principles to the DPSP, some of which explicitly, clearly aim to promote equal justice and to provide free legal aid. Yes. So the 42nd Amendment Act made modifications in Article 39, added 39 capital A, the free legal aid, equal justice for all, then added provisions for Article 43 capital A, and also 48 capital A. Please remember, DPSPs have been modified 4 times. First one was in the year 1976 when 4 changes were made. Second was in 1978, 1 change was made to Article 38. Third one was the 86th Amendment Act, where how many changes were made? Where 1 change was made to Article 45. And the fourth one was 2011, the 97th Amendment Act, right, for the cooperatives. 1 more change was made. Please remember all these 4 changes and what articles were added or modified. It's important for the exam. So 2 is correct. The third one, Article 48 advocating the organization of agriculture and animal husbandry on modern and scientific lines has often been cited in the judicial decisions to uphold laws related to the ban on the slaughter of cows and calves and other milch and draught cattle. Yes, Article 48 is the typical, the popularly known beef ban article, because it mentions that the state shall in particular focus on what? Preventing, placing a ban on the slaughter of cows and calves and other milch and draught cattle. Milch meaning milk producing, which are fit for human consumption, not lions and all, right? Cows, buffaloes, etc. And draught cattle. Draught cattle are beasts of burden. Okay, so 3 is correct. 2 and 3, how many are correct? B, only 2 is the right answer. Next question. In India, which one of the following constitutional amendments accorded the position of legal supremacy to all DPSPs over the fundamental rights conferred by Article 14 and 19? A small clarification here. In 1971, Indira Gandhi said that, we have to achieve the principle of economic equality, 39B and C, reduce the concentration of wealth, distribute countries' resources amongst everybody. So, in pursuance of this, sometimes if we try to take away money or land from rich and give to poor, people start crying that Article 14 is getting violated, Article 19 is getting violated. So, Indira Gandhi made a change, added Article 31 capital C and said that if the state parliament makes a law to give effect to these two DPSPs, even if Article 14 or 19 is violated, that law will not be challenged in the court. This was done through the 25th Amendment Act of 1971. Later on, Indira Gandhi expanded this to say that if I make laws to give effect to any DPSP, even if it violates 14 or 19, you can't challenge it in the court. That was done through the 42nd Amendment Act. Sadly, when this was questioned by the court, Supreme Court accepted this argument that yes, this is okay, but not all the DPSPs. So in the Minerva Mills case, Supreme Court removed this provision saying no. You cannot simply bypass 14 and 19 for every DPSP. 39B and C talk about economic equality. So we can agree on that. But there are other DPSPs which are very, very vague. You cannot simply bypass 14, 19, which are a part of golden rights. The golden triangle of rights. Article 14, Article 19, Article 21. You can't bypass that. So that was struck down. But anyway, the answer is 42nd Amendment, 1976. Next question. Which article of the Indian Constitution safeguards one's right to remain silent? Right to remain silent. No self-incrimination. In the movies, not in India, but in these Hollywood movies especially, you see, they talk about whenever the policeman arrests somebody, he says, you have a right to remain silent and whatever you say can be used against you in the court of law, all that nonsense, right? Reading the rights. In India also that applies. So the policeman, next time he or she arrests you, you please tell them, read my rights to me. They might slap you and all, but polity wins. That's important. So right answer is C, Article 20, because Article 20's third provision talks about no self-incrimination. Nobody can force you into being a witness against yourself. Okay. Next question. Match the DPSPs in list 1 with the articles in the Constitution that best reflect them in list 2. Let's see. So, to secure the right to work and to education. See, in such questions, try to find out the easiest one possible, though the first one is Article 41, but still let's try to solve it properly, as you would in the examination. Some popular ones, like secure for citizens the UCC. UCC is Article 44. Yes or no? Very popular. 3 is C. 3C, 3C, 3C. Oh, we could eliminate only one. Let's try more. To promote voluntary formation of cooperative societies. Always remember cooperative societies. This article is important because it was a later addition, right? This article was added later on. This means this article will have some capital letter attached to it. Let's see 48, 44, 43, B, 41. This one. So this is 43, capital B. 97th Amendment Act. This means B is 2. Okay. Let's see B2 and C3. B2, 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 C3. We have the answer already. Otherwise, also you can simply check here. Fourth one as well. To organize agriculture and animal husbandry on modern and scientific lines. This is again important because it's always under discussion. Article 48, the beef ban issue in our country. So the article becomes important. And then this is Article 41. Where is 41? This is 41. So Article 41. Okay, done. A is the right answer. Next question. In the context of Indian polity, the need for separation of power is best reflected in which of the following options? Need for the separation of power. To separation of power, how can we ensure that? If the judiciary is independent. See, the judiciary is independent means what? The judiciary has a freedom to make decisions based on laws and facts without any interference, any influence from the executive or the legislative branch. So to maintain the independence of judiciary. C. Other options to ensure the supremacy of legislature. How can we have separation of powers then? Decentralization. No, nothing to do with separation of powers. And protecting the rights of citizens. For that we need an independent judiciary first. So C is the right answer. Next question. Consider the following statements regarding the amendments to the DPSPs in the Indian Constitution. Amendments. Okay. The 42nd Amendment Act of 1976 is notable for adding Article 39 capital A to DPSP, which directs the state to promote equal justice and free legal aid. Yes. I am telling this again and again. Please make sure you remember all the amendments made to DPSPs. Correct. The 44th Amendment Act 1978 introduced Article 48 capital A. No, this is wrong. Why? Because the 44th Amendment Act made only one change in the content matter of Article 38. This was done through the 42nd Amendment Act, not the 44th. 2 is wrong. Number 3. The 86th Amendment Act added Article 45 under the DPSP, which mandates the state to provide ECCE, Early Childhood Care and Education, for all children. The content is correct. Words are wrong. The 86th Amendment Act did not add Article 45. No, it amended, it modified Article 45. The content matter was changed. 3 is wrong. How many statements are correct? So only one is correct. Right answer is A. Next question. Consider the following statements. Statement 1. Any arbitrary action by the government limiting the fundamental rights can be challenged in the Supreme Court for the violation of the Constitution. Yes or no? Yes, of course. It can be challenged. Number 2. The Constitution of India is the outcome of rights of individuals. No. Rights are the outcome of the Constitution. Constitution in our country is said to be the source of rights. Not the other way around. So 2 is wrong. 1 is correct, 2 is wrong. Right answer is C. Statement 2 is incorrect, 1 is correct. C is the right answer. Next question. Consider the following statements about amendments. The 86th Amendment Act introduced Article 21A into the DPSP. This is wrong. 21A is not in DPSP. It is under fundamental rights. So you have to follow words very carefully. The point was to read the statement carefully. Article 47 of DPSP, which urges the state to raise the level of nutrition and the standard of living and to improve public health. This is correct. Was enhanced by the 73rd Amendment to include provisions for promoting the consumption of nutritious food. Utter nonsense. Firstly, there is no such provision added, and the 73rd Amendment is a very famous one. This was meant for panchayats. Okay. Addition of the provision for panchayats. Please write in the comment section which Amendment Act was meant to add the municipalities in the Constitution. And the third one, so 2 is wrong. Third one, the 97th Amendment Act included the promotion of cooperative society within the ambit of DPSP. Yes, that is correct. So Which statement is correct? D. 3 only is correct, all others are wrong. One more question. Statement 1 under Article 32, every person has a right to directly move to the Supreme Court for the enforcement of their property rights. Yes or no? See, under Article 32, you can move to court directly only for the enforcement of your fundamental rights. My question to you is right to property a fundamental right? Not anymore. After 1978, it is a mere legal right. You may try to say, sir, at least call it constitutional. Yes, okay. Let's call it a constitutional right because it is still under the Constitution, Article 300 capital A. But it is not a fundamental right. So 1 is wrong. Statement 1 is wrong. This means we have the answer already. Statement 1 is incorrect, but 2 is correct. D is the answer. Let's read the second one. Right to property is a legal right available to every person. Yes. Right to property is a legal right available to every person because this was Article 31 Clause 1, which was later on modified into 300 capital A. So 2 is correct. Next question. Which of the following situations does not violate a person's fundamental right? Levying tax for priests working in religious places. This violates your fundamental right. Imposing tax on a certain religion, freedom of religion gets violated. Okay, fair enough. 16 years old working in a mall. I don't see mall as a hazardous place. So it's a non-hazardous employment which is allowed for adolescents 14 to 18. So this does not violate your fundamental right. Okay, so this is a part of the answer actually. Farmers' land is being taken away for the construction of a highway. Since this is not violating your fundamental right, no fundamental right to property. So this is also a part of your answer because it does not violate. 2 and 3, D is the right answer. Okay. Next question. Consider the following statements regarding the present status of Schedule 9 of the Indian Constitution. It was added through the first amendment to the Indian Constitution. Yes, Schedule 9, Article 31 capital B, the First Amendment Act 1951. Adding any law under Schedule 9 makes it immune from judicial review. That's correct. Okay. Number 2, laws placed in the 9th schedule are immune from judicial review. Oh. Laws placed in 9th schedule are immune from judicial review. The question is important. The question says present status. Originally, yes, but after 2007, the IR Coelho judgment, what has the Supreme Court said? Every law added to Schedule 9 can be tested for the fact that if it violates the basic structure, we can review it and cancel it. So on the touchstone of basic structure, the court can intervene and review it. Otherwise, no. So it is no longer immune from blanket judicial review. There is no blanket immunity now. 2 is wrong. 1 was right, by the way. So which of the above statements are correct? A, 1 only. Next question. How many of the following are not a part of fundamental duties under Part 4A? Not a part of fundamental duties. Fundamental duties, Article 51 capital A. Yesterday I had asked a question for you to write in the comment sections that some of you did write about which other part has been added to our constitution on the recommendation of Sardar Swan Singh committee. Apart from the tribunals, duties was the right answer. A lot of you wrote that as well. To vote in panchayat elections, is that a part of our fundamental duty? Sadly, it should have been there. It's not there. Number 2, to cherish and follow the noble ideals which inspired our national struggle for freedom. Yes, if you look at Article 51 capital A, Clause B, you will find this mentioned there. To protect and improve the natural environment, including forests, lakes, rivers, and wildlife. Yes, this is Clause G, 51A, Clause G. And 4, to renounce practices derogatory to the dignity of women. Yes, of course. This is also mentioned under the same article 51A, clause E. Apart from facts like promoting harmony, the spirit of common brotherhood, etc., and also to renounce practices derogatory to the dignity of women. 2, 3, 4, part of fundamental duties. Voting is not a part. The question said, how many of the following are not a part? Only one is not a part. Okay. Next, in a recent Supreme Court verdict limiting the provision of coverage of MTP to only married women is a violation of which among the following? So we had seen this question. I had explained this question to you. The answer is Article 14. The judgment is the case of Principal Secretary versus NCD Delhi versus X 2022. The court has said that it violates Article 14 if you allow the benefits of medical termination of pregnancy to be extended only to married women. Consider the following statements with respect to the NCSC, National Commission for Scheduled Castes. Every state government shall consult the commission on all major policy matters affecting scheduled castes and Anglo-Indians. NCSC is meant only for scheduled castes, right? Not for Anglo-Indians. It is meant for Anglo-Indians also. And this is nothing but Article 338, Clause 9. Every state government shall consult the commission on all major policy matters affecting scheduled castes. This is Article 338, Clause 9. But Anglo-Indians also, because NCSC is meant to look into the conditions of scheduled castes and Anglo-Indians. Okay? Both. So one is correct. Number 2. The commission has the power to investigate upon complaints and enjoys all the powers of not a criminal code, the powers of civil code. This is a bit too much. Civil code. 338, clause 8. 2 is wrong, 1 is right. How many are correct? A, 1 only. Next question, which one of the following statements best describes the significance of the preamble of the Indian Constitution? The preamble is a symbolic introduction to the Constitution and holds no legal importance. Now, that is too harsh. It does hold legal importance. In fact, the court has said that the Constitution must be read in the grand and noble vision of the preamble. One is wrong. Number 2. The preamble serves as a guiding light reflecting the aspirations and ideals of the Constitution makers. Yes, preamble is the identity card, the essence of the entire Constitution. B is the right answer. The preamble is a comprehensive legal document outlining all the fundamental rights. Nonsense. Nothing of this sort. The preamble is a legally it's not a legally enforceable part. Preamble on its own is not legally enforceable. We can read preamble with the other parts of the Constitution to derive a fuller meaning of the Constitution. On its own, you cannot take the preamble to court. That's not possible. Next question. Fundamental rights are not sacrosanct in nature. Sacred. Sacrosanct means sacred. So fundamental rights are not sacred, meaning can they be modified? Yes, of course they can be amended. One is correct. All the fundamental rights are also available against the action of private individuals. No, some are available only against the state. Number 3, state legislatures do not have the power to make laws to give effect to certain fundamental rights. That's correct. For details, look at Article 35. There are so many provisions where states have no power to make laws to modify your rights. Only center can do it. So, which of the statement given above is incorrect? Guys, not how many. Which statement? B, 2 only. With reference to the Constitution of India, consider the following statements. The original Indian Constitution did not provide for fundamental duties. Yes or no? Yes, we know it very well. It was added in the year 1976 with the 42nd Amendment Act on the recommendation of Sardar Swan Singh Committee. Unlike the DPSPs, fundamental duties are not justiciable. Why will fundamental duties be justiciable in nature? They are also not justiciable in nature. Which of the statements is incorrect? Incorrect. 2 only. Next question. Match the following. Okay, let's see. The 31st, again, try to find out the ones which you know very well, which are easy for you to match. For example, the 61st Amendment Act. This was the Amendment Act of the year 1988, right? This was the voting age. B is 1. Then, of course, we know the 102nd Amendment Act of 2018, it was meant for the creation of the body called NCBC. NCBC. D is 2. B is 1, D is 2. Let's check. B is 1, D is 2. We already have the answer. There is no need to go for the others. A is the right answer. Others are also simple. 100th Amendment Act. This was done in the year 2015. 2015. This was the Indo-Bangladesh Land Boundary Agreement, exchange of enclaves, and the 31st Amendment Act of 1973. This was the increment in the seats of Lok Sabha. Right? Okay. So that's it. Easy to solve. Moving on to the next question. A is the answer here. Consider the following statements about the preamble of the Indian Constitution. The phrase "we the people of India" emphasizes the concept of popular sovereignty, meaning the real power lies in the hands of people, indicating that the power and authority of the government is derived from the people. Yes, the power, the authority, they are both derived from the people. Absolutely correct. We the people of India have given to ourselves this constitution. Number 2, the terms socialist and secular were a part of the original text. No. 3 words, socialist, secular and integrity, were added later on in 1976. The preamble declares the objectives of securing justice, liberty, equality to all citizens and promoting fraternity to maintain unity and integrity of the nation. Yes, that's true. And number 4, the Supreme Court of India has ruled that the preamble is a part of the Constitution and can be amended under Article 368. Yes, it can. The only thing is that the basic structure cannot be amended. Otherwise, preamble can be modified. Right answer 1, 3 and 4. B. Next question. Which of the following principles reflected in the preamble of the Indian Constitution was not explicitly added by an amendment? So we have had 3 words added: socialist, then secular, and integrity. Sovereignty was always a part. India is a sovereign, socialist, secular, democratic republic. 2 words, socialist and secular, were added later on. Sovereignty was a part of the original Constitution, was not later on added through an amendment. A is the right answer. Next question. Consider the following statements about Article 30 of the Indian Constitution. It guarantees all minorities, whether based on religion or language, the right to establish and administer educational institutions of their choice. Yes, absolutely correct. Article 30, Clause 1. This is what it states. One very important point. Our Constitution recognizes that minorities are of 2 kinds: religious, linguistic. What is the definition? That's not mentioned. They have not been defined, but they have been recognized. And also Supreme Court has clarified that religious minorities will be on a country-wide basis. So let's say in a state like Nagaland, if Hindus are less than 50%, you cannot give them the minority status, because religious minorities are based on the nationwide data. Okay, so we simply follow a very generic concept of less than 50%. Though internationally these things vary. In some places it's 20%, some places it's only 5%. This means that you will not be called a minority until and unless your population is less than 5%. But in India we simply say less than 50% as of now. Okay, and linguistic minorities, linguistic, language-based minorities, this is on a state-to-state basis. So a Tamil-speaking person will be a minority in West Bengal and a Hindi-speaking person is a minority in Kerala. As simple as that. Number 2, the right granted by Article 30 is absolute and cannot be regulated by the government. This is all nonsense. How is it possible? See, the right granted by Article 30 is not at all absolute. It is subject to regulation by the government, particularly regarding the educational standards, health, safety measures. The government can regulate these aspects to ensure the welfare of students and also public interest, because everyone has a right to administer their school or college, not the right to maladminister. Because yes, we want to ensure that the culture of the minorities and everybody is protected, but not at the cost of sacrificing what? The standards of excellence. A balance, harmony has to be maintained. So 2 is wrong. Number 3, under Article 30, the state can discriminate against minority educational institutions while providing grants in aid to schools and colleges. No. In fact, clause 2 very clearly says, state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or on the basis of language. Article 30, clause 2, no discrimination. 3 is wrong. What's the right answer? How many statements are correct? Only one, A. Next question. The libertarian political ideology advocates for what? Strong centralized governance and regulatory oversight of personal activities? Of course not. Reduced government involvement to ensure maximum personal and economic freedoms? Yes. See, libertarianism is a political philosophy. It prioritizes individual liberty, limited government intervention, and the protection of individual rights and freedom. It holds that individuals should have the freedom to make their own choices, live their lives as they see fit, as long as they don't infringe upon the rights and the freedom of other people. That's there. And also, libertarianism advocates for minimal government involvement also in both personal and economic matters. In the realm of personal freedoms, libertarians support the idea of civil liberties, such as freedom of speech, religion, forming associations, and they generally oppose any such law that restricts personal choices, and they view these as infringements on individual autonomy. In fact, even on the economic front, if you see, libertarians emphasize on free markets and limited government intervention. They argue that voluntary interactions in the marketplace without excessive regulation or centralized planning lead to optimum outcomes and, of course, economic prosperity. Now, how far this is true is best left for them to decide. And they generally advocate for private property rights, free trade, minimal restrictions on business, entrepreneurship, etc. So, of course, reduced government involvement to ensure maximum personal and economic freedoms. B is the right answer. What is the primary goal of direct democracy? Primary goal of direct democracy. See, direct democracy is a form of government where citizens directly engage in decision making rather than entrusting it to the elected officials. Representative democracy, what we follow. So in such a system, people vote on laws, policies, and other very critical and crucial community matters. So some key aspects of direct democracy would be citizen participation, right? In fact, the foremost goal of direct democracy is to foster active citizen engagement. And this engagement is also in the legislative process. So right now, MPs vote on bills. In direct democracy, people can vote on bills, like some Indian Idol contest. Message has been circulated that tomorrow we are going to attack, or referendums or even plebiscites. Right? People's opinion is taken that tomorrow we should attack Pakistan. Type yes, type Y and send, or type N and send. It can be done, right? So that's there. Apart from it, that would also mean instead of the MPs, the elected representatives to decide for them, citizens themselves take part in the voting and the crafting of policies. Then we also will think of it as a majority rule. Decisions in direct democracy are typically made by the majority vote, right? Where the choices of majority of the participating citizens dictate the adoption of policies and laws. Then the concepts of referendum initiatives. So these are vital tools in direct democracies, allowing citizens to vote on specific proposals, referendums, and to also propose new laws. So citizens can initiate policies and bills, unlike right now only the elected members can or our representatives can. One thing that we also see as an advantage is transparency and accountability. Because, see, by involving citizens directly in this system, direct democracy enhances transparency and accountability in government actions. This leads to more open discussions, better information dissemination, more informed people as well, and thorough scrutiny of proposed laws as well as policies. Now, one challenge that direct democracy has in general is that it's very resource intensive. Now, the implementation of direct democracy demands considerable resources and time, as it also involves, a wide electorate, organizing how people will vote, how to facilitate public debate, how to take signs of people, how to verify those signatures of people, etc. That's a concern. Anyway, so the primary goal of democracy, direct democracy, is what? To enhance individual freedoms? Not really. To implement robust system of checks and balances? Not really. To centralize power amongst select few elite? Of course not. To engage citizens directly in the decision making process through voting? That's the most appropriate one. D is the right answer. Consider these assertions. The Constitution outlines the structure of a state and the rules it must abide by. Okay. Effective constitutions provide individuals with incentives to comply through their stipulated provisions. And number three, constitutions embrace the principle of dividing powers among various authorities. Yes, all three are correct. See, statement one is correct, of course. A constitution indeed provides the fundamental structure of a state and also sets forth the principles and norms that govern its operations and the behavior of its political entities. Statement 2 is also correct. Ultimately, you have to ensure that people have some incentive to comply. Every constitution should have something for every group, every individual in the country. Effective constitutions provide incentives for compliance by establishing a mechanism of rights and, of course, responsibilities that should align with individual interests and also group interests, right? So broader legal and societal frameworks are in place. So adherence to this rule book is encouraged. And 3 is also correct because constitutions typically provide for what? Incorporating the principles of separation of powers, which divides government responsibilities amongst various branches, like the LEJ branch, and also should ensure that any one branch should not gain too much power and there should be a mechanism of checks and balances. This is there. All three are correct. How many statements are correct? C. All three. And the last question for today. Statement 1. The 103rd Amendment to the Constitution of India significantly impacts the principle of equality for citizens. So firstly, we have to know what is this amendment. 103rd Amendment Act was of the year 2019. This was the EWS reservation, economically weaker section reservation up to 10%. Does it impact equality? Yes, of course it does. But is it wrong? Of course not. We are providing for equitable opportunities for people, right? So one is correct. Second one, 103rd Amendment to the Constitution modifies Article 14. Oh no, not really. 103rd Amendment modified Article 15, adding Clause 6, and Article 16, adding Clause 6. So up to 10% seats for EWS in schools and colleges, and up to 10% seats for EWS in public employment, government jobs. So 2 is wrong. This would mean statement 1 is correct, 2 is incorrect, C is the right answer. That's it. We have solved around 45-50 questions from this topic. So I hope you have had a nice time solving these questions. Not just enjoyment, but also knowledge with respect to what to focus on, how to read statements carefully, and also go back and revise. Ultimately, the last few weeks before the exam should be devoted to solving as many questions as you can and selective revision of the topics. That's very important. See, the target of all these sessions is not to replicate or second guess what the UPSC is going to ask in the exam as a direct question. The idea is to find out those important topics, make you realize that these are the important areas to focus on, and also what to expect. Also to make sure that you recollect information, because the more you solve questions, the more you try to recollect information, the more it gets entrenched, embedded in your mind. That's the whole point. Anyway, tomorrow we have the last session on polity. We'll be covering all the miscellaneous topics, including topics like elections, RPA, part 1, part 2, then Article 370, Schedule 5, 6 areas, emergency provisions, etc. Right? So that's going to be it for today, guys. Let's meet tomorrow. Till then, that's all for me. Jai Hind.